We can go to the next slide. So hi everyone, again my name is Patricia Wonder and I'm an instructor at the CUNY School of Professional Studies. I also moderate this webinar series and I'm also a partner of my own law practice, Johnson Wonder PLLC. We can please move to the next slide. We are very lucky and honored today to have two presenters, Elizabeth Newman, who is a Director of Immigrant Initiatives at CUNY School of Law, and also Alan Wernick, who is the Director of CUNY Citizenship Now. We can move to the next slide, please. We have two sponsors of this webinar series, CUNY Citizenship Now and CUNY School of Professional Studies. We can move to the next slide. I wanted to tell you a little bit about CUNY School of Professional Studies. The goal of the School of Professional Studies for CUNY is an Immigration Law Studies Advanced Graduate Certificate Program. And what that is a program designed to offer courses in many areas of immigration law, including Introduction to Immigration Law, Business Immigration Law, Family-Based Immigration Law, Proceedings in Immigration Courts, and Naturalization. We can move to the next slide. If you are interested in learning about these courses and the School of Professional Studies, you are more than welcome to visit CUNY SPS website, which is www.sps.cuny.edu. And at the website, it will give you information on the program, including the description of the program and the courses and any other information you'd want to know about the program. We can move to the next slide. The other sponsor of the webinar series is CUNY Citizenship Now. The goal of CUNY Citizenship Now is to help individuals prepare their application for naturalization. And this is an initiative with the New York City Mayor's Office of Immigrant Affairs. And the goal of the program is to help, on an average, about 8,000 immigrants a year. We can move to the next slide. There are immigration centers all over New York City, and you can see the map on your screen. And the centers offer free immigration services to all members of the community, CUNY citizens and also non-students of CUNY. We can move on. The CUNY Citizenship Now has a group of volunteers that provide this free naturalization application assistance at events in New York City. And if you are interested in volunteering, if we can move to the next slide, you're more than welcome to visit the CUNY website, which is www.cuny.edu/citizenshipnow/volunteer. And it's actually a great time to get involved because in April there's a big call-in with Citizenship Now with the Daily News where anyone from anywhere in the United States can call in and immigration assistance will be provided. And there's a lot of trainings going on in the month of March to help people prepare to volunteer at this call-in event and also volunteer at the weekly application assistance events. So if you're interested, it's a great time to get involved, and please visit the website. You don't have to have immigration experience. So if you have a little or no immigration experience, we will gladly train you. So please don't let that deter you from visiting the website and joining. We can go to the next slide. So that was just a little bit about our two sponsors of this webinar series. We're going to begin the substantive portion, which is adjustment of status. I wanted to let you know that at the end of the substantive portion, we will be discussing question and answers from the audience. So please feel free. You have a chat on the right side of your screen. Feel free to give your questions, and the presenters and I will go over them at the end. So if we can go to the next slide. And I'm going to turn it over to Alan Warnick, who's going to begin our substantive portion. Alan?
Thank you so much, Patricia, and thank you to all the listeners and viewers of our webinar today. So let's begin with the next slide. Adjustment of status refers to the process of getting permanent residence without leaving the United States. The person has their actual interview for their immigrant visa here in this country. The alternative to adjustment of status we refer to as consular processing, which refers to going to your home country for your final immigrant visa interview. And today we want to see who can interview in the United States. There are two. The issue then is the place of the interview, not so much the underlying qualifications. In order to qualify for permanent residence, whether it's consular processing or interviewing in the United States, you have to come under one of the qualifying categories. Adjustment of status is not available unless you qualify under one of the underlying categories, and we will go through them later in these slides. We have family-based petitions, employment-based petitions, and some other categories. In order to help us discuss and understand adjustment of status, for the purposes of this program, Professor Newman and I have broken down the adjustment of status discussion into three categories. 245A adjustment, which is the basic adjustment of status statute, and 245A refers to a section of the Immigration and Nationality Act, 245I adjustment, and miscellaneous other categories. Next slide, please. Just to reiterate, there are two layers to the process of adjustment of status. The first is where are you going to have your interview. That's one part of the process. And then once you have your interview, once that decision is made, once we've evaluated that, the other aspect or the other part of it is to determine whether or not the person qualifies. Actually, in most cases, it's done in the opposite order. I mean, first you want to see whether you qualify for permanent residence, and then you're going to decide where you're going to have your immigrant visa interview. And in terms of eligibility, there are two aspects. One I already mentioned, which is that you have to have some underlying qualification, like a family or employment basis. But the other thing is you have to be not inadmissible. And we're not going to discuss too much about that today, but inadmissibility refers to things such as a fraud in a prior immigration case, a criminal record, a medical condition which may make you ineligible for permanent residence. So what we're going to do today is focus on the place of the interview, adjustment of status if it's in the United States, and again the alternative is consular processing. In prior and in future programs, you can find discussions of family immigration, employment-based immigration, and inadmissibility. So let's go to the next slide. So let's just jump right into our discussion of adjustment of status. And the most immigrants know why adjustment of status is so valuable. But if you're new to this process, let's just review the reasons. First of all, one of the grounds of inadmissibility is that if a person has been in the United States more than 180 days in unlawful status, it's possible that if they leave the United States for consular processing, they won't be able to return for 3 years, or in some cases 10 years, unless they get the unlawful presence grounds of admissibility waived. And that's a risky thing because they can't even apply for the waiver until they go to their consulate. So that's one reason people who are unlawfully here want to be interviewed in the United States. For individuals who are lawfully here, even for them, it's advantageous usually to interview in the United States, and the main reason for that is because if the Immigration Service has a question about your application, you have more opportunities to litigate or to fight about it. You may be able to go before an immigration judge or even in some cases seek federal court review. And finally, in most cases, an individual will be able to remain in the United States pending a final determination on whether he or she is eligible for permanent residence, and usually the individual will not be detained. Now, that's not always true, but in most cases, an applicant who is fighting their application for adjustment of status will be able to remain in the United States through the period of that fight and remain free from incarceration. Let's go to the next slide. Okay, so then the question is, who can adjust status in the who can get their permanent residence in the United States? Well, let's divide this into a few groups. The first group we're going to talk about are immediate relatives of United States citizens. So individuals in this category include the spouse of a U.S. citizen, the unmarried children under 21 of U.S. citizens, and the parents of U.S. citizens where the U.S. citizen is over age 21. Let's go to the next slide. We haven't, this poll question is a little out of order. Can we go back, please? So just so you can get, just to follow the slides, I'm going to discuss who qualifies to adjust status if you're an immediate relative of a United States citizen. If you're an immediate relative, what you must show is that you were admitted and inspected. That means you presented yourself to an immigration officer at a sea, land, or air border, and that officer inspected you, that is, looked at your documents or asked you questions, and then admitted you into the United States. If you're an immediate relative and you meet that criteria of inspected and admitted, you can adjust status. You can interview here. That's true whether or not you have engaged in unauthorized employment, whether you have overstayed. So even if you're illegally here, or you may say if you're undocumented here, you still may be able to adjust status if you're an immediate relative of a U.S. citizen. Next slide, please. Okay, so here's a poll question for you. And what we want you to do is, I'm going to read the question, and then you'll have the opportunity to answer it, and we'll see how you do. So Harry is a lawful permanent resident. His wife, Wilma, see Harry, husband, wife, Wilma, that's help you remember, came here as a visitor and overstayed. What is your advice to Harry and Wilma regarding Wilma applying for LPR status? Next slide. So these are your choices. Wilma can adjust status now. Wilma can adjust status if Harry becomes a U.S. citizen. Wilma can never adjust status, and all of the above is wrong advice. So while you're giving us your answers, I wanted to tell you again a little bit about the School for Professional Studies Immigration Law course. I think it's the most advanced course of study in immigration law with a practical approach of any program in the country. And if you take the introductory course and 2 of the advanced courses, you will get a certificate in immigration law studies. And I should note that all of these courses are offered in classroom in Manhattan or online. So all of them, if it's not convenient for you, or if you're not living in New York City, you can take them online. So do we have any results from our poll? Oh, you're still voting. Okay. Well, take your time. Not too much time. Let me tell you then a little bit also about Citizenship Now and our Citizenship Core. As Professor Wonder pointed out, if you sign up for the core, you'll have a lot of training opportunities, but also you'll be able to give back to your community, because almost every other weekend somewhere in New York City, Citizenship Now holds an immigration event where we provide assistance for citizenship. Okay, let's go to the poll results. So 73% of you said Wilma can adjust status if Harry becomes a U.S. citizen, and that's the correct answer. Here's what you would want to say to Harry and Wilma. If Wilma's out of status and Harry petitions for her, the petition will be approved, assuming it's a real marriage. But she is going to have to go home for her final visa interview if Harry remains only a permanent resident. However, if Harry becomes a U.S. citizen, then Wilma gets upgraded from the spouse of a permanent resident to the spouse of a U.S. citizen. And as a spouse of a U.S. citizen, she comes in the immediate relative category, and she can interview in the United States, which is what she's probably want to do. In most cases, what you're going to find is that Wilma is going to want to interview in the United States, and she's going to wait until Harry becomes a U.S. citizen. Okay, let's move on. So in discussing this question of inspection and admission, there's a few issues that are a little bit more complicated and unusual than your typical case that we talked about with Harry and Wilma. Let's take a look at the question of entry from Canada or Mexico. Up until very recently, in the last few years, sometime after between 9/11 and maybe 2004, 2005, although it still happens today that occasionally people are waved through the Canadian or Mexican border. Any of you who have traveled to those countries may have experienced this. So let's say a person, Johnny, is in a car in the back seat, and he's coming in from Canada, and he doesn't have a visa to enter the United States. He's not Canadian. Let's say he's Jamaican. And the person in the front seat is asked for his passport. He shows the passport to the inspecting officer, and the car is waved through. Now, under immigration law, that is an inspection and admission because he presented himself to the immigration officer. The immigration officer had an opportunity to ask questions, and he was admitted. So that person is eligible as a person who was inspected and admitted, and if an immediate relative would be able to interview in the United States. The problem may become whether or not the applicant can prove he or she is inspected and admitted, and that, of course, is a question of presenting evidence. That might be an affidavit. That may be from the applicant. That may be an affidavit from somebody else that was in the car. It's not uncommon for the Immigration Service to deny an application for adjustment of status on a case as I described. If the person is Canadian, then it's less likely to be an issue. But if the Immigration Service denies the application, the individual can renew the application in an immigration court before an immigration judge, and the person is more likely to be successful. The reason is that the immigration judge will have an opportunity to observe the demeanor, that is, how the person presents him or herself. And if the immigration judge believes the applicant, then the judge will grant permanent residence, and that's quite common. So that's entry from Canada or Mexico. Suppose somebody comes in with phony papers, let's say his brother's passport, comes into the airport, he looks like his brother has a visa, he presents a passport. That's considered an admission. That's considered an inspection and admission, and the person is eligible for adjustment of status. Again, he or she will need to convince the USCIS adjustment status examiner of the qualifications for adjustment of status, and if the application is denied, then an immigration judge can consider the application anew. It's best if the applicant has the document. So if a person says, look, I came in with my brother's papers, and here are those papers, then the individual is going to have a better chance of getting the immigration examiner to approve the case. If the person no longer has the papers, and that's very common. Suppose Johnny pays money to get a passport from somebody in another country, and then after he comes to the United States, he has to give back the passport. Now, Johnny has no proof of how he came to the United States. Let's say he came here from an African country. Well, in that case, he may submit an affidavit. He may submit an affidavit for someone met him at the airport. But again, if the Immigration Service denies the application, as is often the case in the case I described, he can apply before an immigration judge. One thing I'd point out is that in both of the examples I gave you, the person committed fraud, at least in the eyes of the Immigration Service. So he or she will need a waiver of that fraud, and will be able to get that waiver if he or she can show extreme hardship to his U.S. citizen or permanent resident spouse or parents. There's also some exceptions to the inspection and admission rule. C and D non-immigrants cannot adjust status under 245A, even if they were inspected and admitted. C refers to individuals who are admitted for the purpose of spending time in the United States while waiting to go to another country, and D non-immigrants are crew members. These individuals cannot adjust status under 245A, even if they were inspected and admitted. The same is true for a person in transit without a visa or a trove. A trove is a person who shows up at the airport, does not have, or another port of entry, does not have a C visa, but has a long layover in the United States. The person can be admitted after inspection by an immigration officer as a trove, but he or she cannot adjust status under 245A. A fiancé of a U.S. citizen who does not marry the citizen who brought them here, those people cannot adjust status under 245A, and the same is true in some jurisdictions for a K-1 fiancé who marries after more than 90 days after entry. And now on this last point, let me just mention that there's litigation, which means fighting in court over whether or not a person who marries the U.S. citizen who brought him or her here after 90 days can interview in the United States, can adjust status. In some jurisdictions, they can. In some jurisdictions, they can't. So we're not going to go through all of that since this is a national broadcast. Remember that just because the person cannot adjust status doesn't mean he or she cannot be a permanent resident. So for instance, let's say a person does not marry the U.S. citizen who brought them here, he or she can go back to their country for consular processing, but they may face other problems if they do. So let's move to the next slide. So here's another poll question. I know you'll get this one easily because you've been listening so carefully. Frank is married to a U.S. citizen. He came here using his brother's passport, which had a valid visitor's visa. Can Frank adjust status to lawful permanent resident? And here are your choices. Frank cannot adjust status. Frank can adjust status, and he does not need a fraud waiver. Frank can adjust status, but he needs a fraud waiver. None of the above. Now, while you're answering the question, let me just say I always like these multiple choice questions because the answer is on the same page as the question, so it should be quite easy for you. These webinars are offered every month, and we hope you'll recommend them to your friends. If you are not able to participate in a particular webinar, they are recorded. Of course, if you listen to it as a recorded webinar, you will not be able to ask questions, but the webinars are recorded and posted on YouTube, and you can get a link at our website, cuny.edu/citizenship now. Okay, so do we have a substantial number of answers? Good. So let's see how you did. Very good. See, you've obviously learned something because it was 73% with the right answer. Here we have 88%. Frank can adjust status but needs a fraud waiver. And by the way, those of you who got it wrong, that's not such a bad thing because it means you'll probably remember the rule better than the people who got it right. The reason Frank needs a fraud waiver is he came in with his brother's passport. So the way the Immigration Service looks at it, and I don't necessarily agree with this interpretation, is they were not able to do a fair review of Frank's qualifications to enter with the visa that he presented because they thought they were interviewing Frank's brother. So he would need a fraud waiver, and he would have to show extreme hardship to his spouse or parent who's a permanent resident or U.S. citizen, but he could do that in the United States, and again, if the application was denied, he could seek review before an immigration judge who could also consider the waiver and possibly seek review by the federal courts. Okay, let's move on. Oh, okay, so this is just, now we're going to talk about who qualifies under 245A who are family preference applicants. They're listed here. You can go back and take a look at them. But we're going to move on to the next slide. So if you're in one of those 4 family-based preference categories, the rules under 245A are a little different. You have to be inspected and admitted or paroled. And by the way, the same issues regarding inspection and admission of parole, issue of fraud, and other questions we talked about, Canada, Mexico, they all apply. But the difference is that if you're an immediate relative, the immigration laws forgive you if you've engaged in unauthorized employment or you're here illegally. They do not if you are in one of the family preference categories. In those categories, you must have never engaged in unauthorized employment and you must never have been out of status. And finally, you must have a visa available. That means that you're at the front of the line under the visa quota system. For an immediate relative, you're always at the front of the line because there's always enough visas for the immediate relatives of U.S. citizens. But there's sometimes a wait in the 4 family preference categories. So let's move to the next slide. Okay, so how do you know when you get to the front of the line? Your priority date or your place in line is established when the Immigration Service receives the petition filed by the U.S. citizen or permanent resident relative. Every month, the Department of State issues a visa bulletin, and you see at the bottom of this page the address for that to get that visa bulletin, and you can also have it emailed to you, and you can phone in, and all that information is at travel.state.gov. When there are more people that want visas in a particular year because there's an annual limit of 270,000 visas in the preference category, and they're also broken down by the four preferences, and by there's a limit per country. When there are more people wanting visas than there are visas available in a particular year, the preferences get oversubscribed is the term we use for that. So when they're oversubscribed, you have to wait. And in order to be eligible for permanent residence, your priority date must be what we say is current. That means that your priority date, the day your relative petition for you, is before the cutoff date for your country in your category on the visa bulletin. Sometimes a person who is eligible for adjustment of status because their visa preference category and their priority date is current files for adjustment of status, but by the time the Immigration Service interviews the person, the cutoff dates have gone backwards, or we say have retrogressed. That's a bummer when that happens, because that means that you're eligible to file for permanent residence, but by the time you got your interview, there's no visa available. Not to worry, because what happens in that case is immigration will interview you, decide whether you qualify for permanent residence, but then hold your file until you get to the front of the line. And in the meantime, you're able to stay in the United States in most cases, and you're able to work in the United States. Okay, let's go to the next slide. So, employment-based preferences. And here's a list of the employment-based preferences. Again, I'm not going to go through them. We recently had a webinar on family-based immigration, and very soon in the future, we will have a webinar on employment-based immigration. So let's go to the next slide. And by the way, you can look at these slides, of course, if you want to, when they're posted on our website. So if you're applying in one of the employment-based categories, that means you're being sponsored by your employer, or you have a unique talent or experience, or you're outstanding in your field, or you're an investor. You follow the same rules for adjustment of status as family-based preferences. That includes having a current priority date. That includes never having engaged in being unlawfully present or engaged in unauthorized employment, with one exception. For employment-based preference applicants, you may have been unlawfully present or engaged in unlawful employment for up to 180 days. This includes your spouse and unmarried children under 21 can benefit from having, even if they've been here 180 days unlawfully. You count the 180 days from the last admission, and there's a couple very technical points, and that is that the Immigration Service, in my opinion wrongly, has interpreted these rules so that if you have engaged in unauthorized employment and then you file your application for adjustment of status, they continue to count your being unlawfully here until you are interviewed for your permanent residence and you get your permanent residence. So if you have 170 days of unauthorized employment and then you file your application for adjustment of status, you better make sure that you stop working before the 180 days. However, your time unlawfully here is an overstay, does not count beyond the time you file for adjustment of status. And in a employment-based case, your priority date, we note, is established by the filing of a labor certification by your employer, or in some cases merely by filing an I-140 petition. So let's go to the next slide. Good. So I'm done, and we'll pass it off to Professor Elizabeth Newman.
Okay, so I want everybody out there to take a deep breath. Professor Wernick has covered a great deal of territory very skillfully, but it's dense. So I hope you'll have a little bit of more capacity to continue. Okay, so the first thing, as a quick recap, right, what we've seen from what Professor Wernick has just gone over, there's very clear restrictions on who is able to adjust status here in the United States, and those would be based on, next slide please, on 245A, which is the section that is principally used, and 245C, which is the section of the Immigration Act that has all of the infractions that one can commit that would make you ineligible for 240 for adjustment of status, right? So there are many people, unfortunately, who perhaps are married to U.S. citizens and can't adjust their status because they came in without inspection, or perhaps they overstayed a tourist visa and married a legal permanent resident, and until the legal permanent resident spouse can become a citizen, and not everybody can, people are stuck in limbo. Right, so I might have an approved petition from my U.S. citizen spouse, but because I came in without inspection, I do not have a chance to adjust my status here. And as Professor Wernick had indicated, if I travel to try to have my interview instead at the consulate, but I've been out of status, I could potentially become inadmissible and be barred from returning for either 3 or 10 years, depending on how long I have been out of status. And just as a footnote, if I've been out of status for over 180 days, that corresponds to the 3-year bar. And if I've been out of status for more than 365 days, that could buy me a 10-year bar. Okay, next slide. So my portion is going to go through how can we wiggle around these restrictions. Can we help people who normally couldn't adjust their status to be able to do so? So I'm going to discuss the two other categories from the earlier slide. We were going to discuss 245A, which Professor Wernick has done, and now I'm going to go over 245I, which is the most popular exception, and then a couple of other ones as well. So 245I is another section of the Immigration Act that allows for some people to adjust status even though they wouldn't ordinarily qualify under 245A. So initially it was a 3-year experiment to try to alleviate backlogs at the consulates because so many people did not qualify under 245A that they had to travel back home. So that has been extended twice, once through 98 and then again through 2001. And it was up for discussion for extension again. However, all of the results of the attacks from September 11th really derailed that conversation. It has not presented itself in Congress again. So as of today, this law is not on the books. However, as you'll see, if people have ties to older applications from when this law was in effect, sometimes we can still use them. Okay? Next slide, please. All right, so before we get into the nuts and bolts of 245I, I just want to be very clear about two common misconceptions. We'll often hear our clients say, oh, I filed for 245I, as if it were a path to legal permanent resident status, or I'd like to file for that. It is not the same as a basis. It's not a family-based petition. It's not an employment-based petition. All 245I is an exception to where that interview can occur. It's not a basis in and of itself. Okay. The second thing I want to underscore is that 245I, if we are using that provision, it does not provide specific protection from those 3- and 10-year bars that I just mentioned and that Professor Wernick had gone over as well. So it can be protection in that if I have unlawful presence, but I'm doing adjustment of status here in the United States, I don't have to be subjected to the bars. What triggers the bars is if I leave. But if I'm filing for adjustment of status under 245I, but for some reason I choose to leave, I've still triggered those bars. Okay, next slide, please. Okay, so 245I has a grandfathering provision. So as I said, it's not in effect today, but if we can find a tie back to an application when the law was in effect, then we can still take advantage of its benefits. So first, the only types of applications that count as a basis for 245I would be a family-based or an employment-based petition. Okay, and those applications have to have been filed within a particular time frame. So the critical dates are applications that were filed before this January 14th, 1998, or after the extension that would be before April 30th, 2001, and that has an extra provision that you must prove that you were also present on the day of the enactment of that extension, which would be December 21st, 2000. Next slide, please. Now, the Immigration Service has had a very generous interpretation of those grandfathering provisions. So the right to 245I remains with the person, not the application. So what this would mean would be that if my spouse applied for me in 2000, when the 245I extension was still in effect, but that marriage breaks up. But now, a petition that my sister, who's a U.S. citizen, had done for me is now current. Even though I'm not following through on the petition that my ex-husband had filed for me, I still can have a right to 245I based on the fact that the prior application had been filed, and the right to 245I remains with me, even though I'm not using that same application to adjust my status. Okay, now, the caveat is that that application, well, in this case with my ex-husband, right, at the time it was filed, it had to have been properly filed, and that means that it needed to be timely, it needed to be signed with an original signature, and the proper fee attached. The other thing is that it had to be approvable at that time. Okay? It means it was a genuine basis. I was really married to my husband. We really intended to be married. But the fact that it failed, either because the marriage broke up or perhaps my husband didn't earn enough for the other provisions, if for some reason the application failed, it still allows me a right later to use 245I as long as it was a real approvable application at the time it was filed. And these benefits also extend to any derivatives. Following the rules of the preference categories, if a derivative could have followed that initial petition, then the derivatives also have a right to be grandfathered under the provisions of 245I. Next slide, please. Okay, so here's another poll question, and now they're getting a tad more difficult, okay? So pay attention. All right, so we have Elsie. She's a 46-year-old woman from Honduras, and she entered without inspection in 1999 and never filed for legal status. She marries a U.S. citizen who wants to petition for her. Okay. Now, the plot thickens. You take a family history and you learn that when Elsie was just 10 years old, her mother left her in Honduras in order to work in the United States as a domestic worker. Now, that employer filed a labor certification for her mother, but never followed through with that application, and she left the job. The mother still has no status today. The question is, can Elsie benefit from this family history to help her get status now? So I'll give you a few minutes to think about this. This fact pattern is a little bit more complicated, so I'll give you hints as you go along. You always want to look first at the primary provisions of adjustment of status under 245A, thinking back to everything that Professor Wernick had taught us. But then, if it fits, you can stop right there. If it doesn't, you'd have to look on to the provisions I just discussed under 245I and see if it follows through the steps to be included or be grandfathered in those provisions under 245I. Even in all of the attempts at comprehensive immigration reform over the last several years, this provision about 245I has really not been returned to the table. So again, many people will continue to be stuck in legal limbo that might be married to U.S. citizens, yet unable to adjust their status because of an immigration infraction they entered without inspection, or had in some other way violated the provisions under 245C that make them not eligible to adjust their status here in the United States. Okay, so hopefully you're all thinking through the questions. Take a shot. I promise I'll go over it. Okay, so here's what we have. Okay, good. So 66% of you have gotten the absolute right answer, which is yes. Oh, I should go through the questions, right? I didn't do that. As a derivative on the petition that was filed before the January 14th, 1998 provisions. So let's just unpack this a little bit. So first, we would look at 245A, and we see that nope, because Elsie had come in without status, she would not normally be able to take advantage of 245A, even though she was married to a U.S. citizen, because she was not admitted, inspected, and paroled. But the family history we're going to explore to see if it could fit under the provisions of 245I. Now, fortunately, she will be able to. The petition that was filed for her mother was a petition that was approvable at the time, and it was filed within a time that 245I was in effect. And being only 10 years old, as a minor, she could have been a derivative on that employment-based application. So in spite of the fact that the employer did not follow through with the application, in spite of the fact that her mother no longer works for that employer, and in fact never found a way to adjust her status, the fact that that petition was filed does give Elsie a future right to use 245I at a future date and with a different application. Her mother, too, if something comes up and her mother has a route to legal permanent residence, will also be able to say, if she can prove that she did have this application filed on her behalf, she'll also have that right that will remain with her as well. Next slide, please. Okay, so we've finished our discussion of the first exception, 245I. Now I'm going to discuss another exception under the provisions of the Violence Against Women Act, also known as VAWA. And this was an attempt by Congress to help women, or spouses, I should say, the law is gender neutral, who are being abused by U.S. citizens or legal permanent residents, and that part of that abuse is the threat that they would lose their status if they leave the abuser. So what Congress did was included people who have as a basis for their legal permanent residency a self-petition based on domestic abuse. So those would be the spouse or minor children of a legal permanent resident or a U.S. citizen. If that is the basis for the legal permanent resident status, then Congress has said we're going to include that group of people in 245A regardless of how they entered the country. The last point on this is that they still have to follow the regular family preference system. So either they're an immediate relative, the abuser was an immediate U.S. citizen, or they have a current priority date. So they still have to follow the family preference system, but they then would be able to be included in the provisions that Professor Wernick had discussed under 245A. Next slide, please. All right, so here's our second poll section for this section. Okay, Annie is from France. She suffered domestic abuse by her legal permanent resident husband. Now, he filed a spouse petition for her in January of 2009, but the couple separated because of the domestic violence, right? The self-petition that you filed was approved. Congratulations. And the question is, one more piece of information is that Annie and her minor daughter, June, overstayed their tourist visas when they first entered. So the question is, can Annie and June adjust their status here in the United States? And if so, when can they do that? Okay, so the potential answers are no, she was not inspected, admitted, or paroled, so they can't adjust status. Or 2 is yes, because she is an immediate relative. The next is yes, because she has a VAWA self-petition as the basis. Or the last answer is that only Annie can adjust status, but not June. So you'd think about this. Again, following the pattern that we had discussed, look at 245A. Does she normally fit into those provisions? Look at 245I or the VAWA provisions we just discussed. And if it would have been a category that allowed for derivatives, could Annie include her daughter June in her process as well? So this is a little bit loaded. You have to think on multiple levels and incorporating the information throughout this whole webinar. So please try to pick your answer, and I promise we'll go over it. It's anonymous, so just take a guess if you need to. Okay, so here's what we have. Very good. The vast majority of our answerers got the correct answer, which is yes, because she has VAWA self-petition as the basis for her legal permanent resident status. So normally we know that the spouse of a legal permanent resident husband, as Annie was, who's currently out of status because she overstayed her tourist visa, normally would not fit under the provisions of 245A, right? However, because VAWA is the basis of that application and the provisions of 245A have been amended to say inspected, admitted, and paroled, or having a VAWA basis for that petition, we don't have to worry about the fact that she overstayed. And it doesn't even matter that her spouse was not a U.S. citizen. Okay, so we want to illustrate that these exceptions are broad. Okay, so she can be included in 245A because of the basis of the petition. And her daughter, because she could have been included on the self-petition, would also have the same right to adjust as her mother does under 245A. Now, the second part of that question was when. Is she ready to do that now, or does she have to wait? And what you'd have to know is you'd have to look at the visa bulletin that Professor Wernick had alluded to, and there's the web address was in a prior slide, and you'd have to check that as the spouse of a U.S. citizen, is there a current priority date? And as soon as that priority date becomes current, then both Annie and her daughter would be able to adjust their status under the provisions of 245A. So it's not immediate because her husband was not a U.S. citizen, but she would follow the family-based process but be excused for having overstayed. Okay, next slide, please. Okay, so now the next category of exceptions to the provisions of 245A, adjustment of status, well, actually, it's not even exceptions. We just wanted to make sure, without taking a great deal of time on these, that all of the people in the audience recognize that family-based petitions and employment-based petitions, while they're probably the most popular ways that people immigrate to the United States, they're not the only ways. And you might have people who you meet who have different bases for wanting to be, different bases to become legal permanent residents. And if they do, there's different sections of the Immigration Act that dictate how their adjustment will go. So these are just a few. This is not a conclusive list. So 245H deals with special immigrant juveniles, and for those who aren't sure what that is, there's a site here that can help you read up on it. Those are minors who are here and have been through a family court process that have made them under the jurisdiction of the family court, and they're able to adjust status under a different section. 245L is for victims of trafficking. 245M is for crime victims who have gotten U visas and have been assisting law enforcement in the investigation or prosecution of that crime. And 209 is the section that asylees or refugees after a year in the country would use to adjust their status. And you would clearly have to look under those provisions to see the specifics of how to adjust under each one of those. Next slide, please.
Okay, so let me continue, and I'm going to go through this part quite quickly because I want to make sure we have plenty of time for questions. When you apply for adjustment of status, you have to file Form I-485. You need to include a medical exam from a USCIS certified doctor, and you see, or what they call civil surgeon. You see an address there where you can go to get a list. You cannot use your own doctor unless your doctor's on that list. If you have a current priority date and your family member or employer has not yet petitioned for you, which of course would always be the case in the immediate relative category, since there are no priority dates for immediate relatives, you may file your application for adjustment of status concurrently with your qualifying petition. So let's move to the next slide. And here are the fees. I'm not going to go through them. You should take a look, but note that there are different fees based on the individual's age. If a person is 79 or older, they need not pay the biometric fee, and there are other exceptions as well. If you are simultaneously filing an employer petition, an entrepreneur petition, or a family petition with your application for adjustment of status, these other fees apply. So let's go to the next slide. You're also going to need, in a family case, in most family immigration cases, and there's some exceptions, but in most family immigration cases, you're going to need an affidavit of support submitted with the application for adjustment of status. The affidavit of support is required by law so that the beneficiary, if he or she runs into financial distress, there's been a commitment by the person signing the affidavit to support that individual. It is required in family immigration cases, so under the immediate relative and the four family preference cases, the petitioner must submit an affidavit of support. If the petitioner does not make sufficient income, for instance, let's say a U.S. citizen who's on public assistance is filing for her mother. The person on public assistance must submit, as a U.S. citizen petitioner, an affidavit of support, but then she can use a joint or co-sponsor. Sometime in the future, we will have a presentation on affidavits of support and how to document them, but it's just a rule to remember. If the petitioner is deceased, you can use a substitute sponsor. If that sponsor is living in the United States, is a U.S. citizen or permanent resident, and is one of the relationships that's listed on the slide. Let's go to the next slide.
Okay, so I wanted to go over the procedures for filing under some of the exceptions that I had covered. So under 245I, it's not instead of, but in addition to everything that Professor Wernick had just said. So in addition to the filing 485 and those filing fees, there's an additional form, the 45A, and a fee of $1,000 for every family member that's 17 years old or older. That person must also show proof of the underlying application that ties you back to 245I, right? So if we think back to our poll questions, Elsie would have to have some proof of the employer's application that was filed for her mother, and then proof that her mother is her mother. And she would need that to accompany the I-485A application. And then don't forget that for those folks who are using 245I in the extension period, they would also have to show that they were present on the date of enactment of the Life Act, which was 12/21/2000. If they're filing after the initial period for 245I, the 98 date. And people remember what the second date was? It was for people who were filing April 30th of 2001 or earlier. Okay, next slide. Okay, then for the exceptions that we discussed under VAWA, adjustment of status is a tiny bit different as well. We still have to pay the regular fees, although for people who are in some kind of financial distress, there are waivers available. Medical exams, yes, they're still required, but in this case, there's no affidavit of support needed, and if you think about it, that completely makes sense. There's no sponsor. The whole purpose is to not have to be tied to the abuser who would have been the sponsor, but the applicants do need to file the I-864W, which is a waiver of the affidavit of support. Just also, it's a good idea to put in evidence that the person filing can support herself, because one of the charges of inadmissibility is public charge that usually is overcome by the affidavit of support. But in this case, because there isn't an affidavit of support, you still want to cover your bases. So even a job offer or evidence that prior to the domestic abuse the woman did have a solid work history, anything like that is helpful to put in as well. Next slide. Okay, and regarding the other areas that we discussed, where family-based or employment-based is not what is the basis of the petition, generally there's fewer grounds of inadmissibility. And that would be discussed more fully during that webinar. You'd have to check with the specific provision and read through it thoroughly to know the full parameters. But generally speaking, there's no interview, which makes it nice. It's all generally done on paper. The exception is if your client has a criminal conviction that immigration wants the right to scrutinize a little more carefully, then there may be an interview. And also note that some of those statuses requires that you are in that status for a specific amount of time before you would be eligible to adjust status. So for example, if you're using the provisions of you were granted political asylum, you have to remain in that status for 1 year before you can do adjustment of status. Similarly, for the U and T visas, crime victims or trafficking victims, you have to have had that visa approved and remain in that status for 3 years before you're eligible to adjust status. But again, you'd have to go back and check on those provisions to make sure you're covering all your bases. Next slide. Okay, and this is just a reiteration. These are just some sites that will help you learn more about those other underlying bases that I had talked about. Next slide.
Okay, so I want to thank Elizabeth and Alan for that really well-informed presentation. And now we're going to go into your questions and answers, and Alan will go over the first question. Alan?
Great, thank you, Patricia. I just want to thank Professor Wonder for doing such a great job in organizing and moderating this webinar, and to Professor Newman for excellent presentation, and to Antonio for excellent technical assistance. So the question is, when is it okay and not okay to engage in unauthorized employment when filing a green card application? Well, I think the government would tell you, if you ask them, it's never okay to engage in unauthorized employment. I think the question that I can answer for you is, whether unauthorized employment will negatively impact your application for adjustment of status. In an immediate relative case, it will not impact your eligibility to adjust status to interview in the United States. In a family preference case, if you engage in unauthorized employment before you apply for adjustment of status, it will make you ineligible to adjust status, that is the interview here, and you would have to go home for your interview. Once you file your application for adjustment of status, in a family immigration case, unauthorized employment will not make you ineligible. And in an employment case, if you engage in unauthorized employment no more than 180 days through the time you become a permanent resident, those 180 days will be forgiven. More than that, and you will be ineligible for adjustment of status. And in the other categories that were discussed by Professor Newman, VAWA and the other categories, unauthorized employment is not a bar to adjustment of status.
Well, thanks, Alan. And just to reiterate, the general rule is unauthorized employment is usually not okay with immigration. Of course, there's exceptions. In immigration law, there's usually exceptions for every rule. And if you are contemplating filing a green card application and you're an applicant and you have engaged in unauthorized employment, I think it's really important, and Alan and Elizabeth will agree, that you seek some attorney or representative to assist you to determine if you meet that exception. You could definitely contact one of the CUNY immigration centers or seek out an attorney to assist you before you file that application when you've engaged in unauthorized employment. And we'll move on to Elizabeth Newman with the second question.
Okay, the second question is, can the spouse and or daughter of a U.S. citizen file for adjustment of status in the U.S. if they are on B-2 visa and overstayed? Okay, so, well, if we think about our presentation, what we'd be talking about probably is immediate relatives, right? The spouse, I'm assuming that the daughter in this case would be minor, right? If you're over 21, you no longer fit into that special category of immediate relatives. So, can the spouse and daughter of a U.S. citizen file for adjustment of status in the U.S. if they've overstayed their visas? Okay, well, let's try to be methodical about it. We'll think back to Professor Wernick's presentation about 245A, and we take a look. We have an immediate relative. If they had come in on a B-2 visa, they were, in fact, inspected and admitted. So it looks like they would be okay under 245A. And in this case, the fact that they overstayed is not going to bar them from doing the adjustment of status application. I think we had a similar question back in the poll question, right? Now, if that spouse was not a U.S. citizen but was a legal permanent resident, we'd have a different answer, right? Because only immediate relatives can have that status, that luxury, really, that in spite of the overstay, they can still do adjustment of status. But it looks like this spouse and daughter of the U.S. citizen would be okay to file adjustment of status, assuming that all of the other bases were correct, that they properly filed the family petition. Anything you'd like to add?
No, that's very good. Thank you. So the next, Professor Wonder, did you want to add anything?
No, I didn't want to add. I did just want to reiterate the importance of the daughter being a minor. So if they were not a minor, then it wouldn't apply. But I think Professor Newman did a great job. So Alan, why don't you go on to the next question?
Okay, so the next question is, am I qualified after listening to this webinar to prepare and file a green card application for a friend? So being a lawyer and a professor, I have to parse out some of your words in your question. Qualified, let's say qualified meaning, if you mean as a matter of law, no, you're not qualified. In order to provide legal advice, you must be an attorney. You must be accredited by the by the Executive Office for Immigration Review, or in most states you can advise a relative. But note that the Immigration Service and many state attorney generals are looking very carefully at individuals who practice law without a license. So we can't say that you're qualified unless you meet one of the categories that I mentioned. I think really what the questioner is asking is whether he or she has enough knowledge. And here's what I would say about that. Certainly we have not covered everything you need to know to decide whether a person qualifies for adjustment of status. We have not discussed, at least in this webinar, family and employment-based relationships, which you have to qualify or detail VAWA or any of the other categories. Nor have we discussed grounds of admissibility, such as fraud, criminal activity, disqualifying disease. However, I'm a firm believer that immigration law is learnable. It's one of the most complicated of areas of law in the United States, but it is learnable. And an individual who applies his or herself to the problem, studies, can find a lot of information on the internet, can take our courses, and learn enough to figure it out. But it is not easy, and certainly, to go from this webinar to helping somebody get permanent residence, I think would be a big mistake.
Yeah, I completely agree, and I would add that the best service you can provide is to learn what the red flag areas are so that you can recognize that if there's a criminal conviction or if there's unlawful presence, that maybe you ought to check with an expert. To be able to know when it's not a straightforward application is very important because remember, you're putting people in jeopardy by filing anything. If you've missed something and they're actually inadmissible, somebody who's been here for many, many years can end up in removal proceedings and have to return to their home country.
Thank you. I just also want to point out that we will be discussing in an upcoming webinar in June the unauthorized practice of law. So for anyone out there who's interested in when you can or cannot file on someone's behalf and whether or not you're qualified, please look for that webinar that's coming in the next couple of months. So Elizabeth, if you could go to the next question, please.
Yes. The next question is, if I have overstayed my visa for 180 days, when can I apply for a green card? All right, I like this question. So we're going to be unpacking the idea of unlawful presence, right? All right. So the first thing is that we need to have a basis, right? We would have to imagine that if we're even in the conversation about applying for a green card, that the person has a basis for doing so. So there's a family-based or an employment-based petition behind this question, okay? Assuming that's so, then the next step would be looking at the effect of the 180 days of overstayed visas with regard to adjustment of status. So this is loaded. So first we're making the assumption that there's a basis, right? Next, we'd have to know what that basis is to see, before we can even begin our regular analysis of does somebody even qualify for adjustment of status? Is it for, if this question was the spouse of a legal permanent resident who came in on without inspection, no, actually it says overstay, right? But if it's the spouse of a legal permanent resident who overstayed more than 180 days, we're not going to be able to do adjustment of status anyway, okay? Now, the effect of the 180 days, here's where it comes in. If you travel, all right? The unlawful presence by itself doesn't trigger those 3 and 10-year bars until somebody voluntarily travels outside of the United States. So if this is a scenario where it's the spouse of a U.S. citizen, for example, who would normally be able to qualify in spite of the overstay as an immediate relative under 245A, then that unlawful presence will not prevent her from becoming a legal permanent resident, and she could apply for her green card right away. If, however, that person got all excited that they were finally back in legal status as they're applying for adjustment of status and chose to travel back to the home country to visit somebody or to go up to Canada to see Niagara Falls, then we've got a problem because in spite of the fact that they have filed for adjustment of status, they have voluntarily crossed the border and they have triggered the bar. So if we are more than 180 days, that would be a 3-year bar. But again, it's really important to remember that it's the travel outside the U.S. that triggers those bars. If there's no travel, which is really the whole point of why adjustment of status is so valuable to so many people, if they don't have to travel, then that unlawful presence will not be held against them. And if they did qualify for 245A to begin with, they can continue with that process.
That's a great point about the traveling, which is really important when you're dealing with someone being an overstay. I also want to point out that if the person was here, let's say hypothetically the question is the person was here under 180 days as an overstay, then they might also fall under the exception for an employment-based green card under 245K. So if you are an applicant or you're working with an applicant who has been an overstay, then you would definitely want to speak with someone, an attorney or credit representative, to see if they qualify for an exception to someone applying when they've been an overstay. So Alan, can you go to your next question?
Okay, thank you. The next question is, an individual enters the United States illegally and has worked illegally. Can they apply for a green card? So this is basically what the whole presentation has been about today. So let's review some of the key points. First, the question is, the person entered illegally. Now, there are two ways that people enter illegally. One, they enter without inspection, which typically would be a person who crosses the Canadian or Mexican border without speaking to an immigration officer, in other words, surreptitiously, doesn't encounter any immigration officials. Or we could talk about a person who entered the United States illegally using fraudulent or phony documents. In the second case, the person can adjust status if they are an immediate relative of a U.S. citizen. If they're not an immediate relative, they would have to go home for permanent residence. If a person is entered without inspection, they're for sure going to have to go home to get their permanent residence, unless they qualify under 245I or one of the other categories that we have discussed. And again, it's worth emphasizing that the people who go home, if they've been here more than 180 days, will need a waiver in order to come back. And the point again that I would make about that, and it's something that I'm calling upon President Obama to change. It seems to me totally unfair that the Immigration Service won't decide a waiver until the person is before the U.S. consul. It'd be just as simple for the Immigration Service. In fact, it would be easier for the Immigration Service to allow a person to apply for the waiver before he or she left the United States. Then, if the person was granted the waiver, knowing that they're going to be unlawfully present, in other words, prospectively unlawfully present, that would be a great benefit. But that's not how the Immigration Service looks at the law. Maybe they'll change.
Okay, thank you, Alan. And Elizabeth, if you can go to your next question.
Sure. This is an interesting question. What are the consequences of filing a green card application using a fake Social Security number? Okay. Well, this is a wide open question. So here's where I would start. First of all, if somebody doesn't have a Social Security number that's really theirs, there's really no need to put that on the application. An application, if an application is has that box left blank for a Social Security number, there's no consequence in the processing. So that would be the first question. It depends where you're coming into the process. Now, for example, if, say, a notary filled that out and didn't pay attention to the fact that it was not a valid Social Security number, and filled that in and sent it off, and now somebody's coming to you with that problem that it is already on the application, then we'd have to analyze what the effect of that is. Now, I would say that attorneys have a duty to correct the record. So if there's incorrect information there, it's not a valid Social Security number, it's a Social Security number that exists but somebody else's, you would have a duty to correct the record. What would be the consequence of doing that? Or say it came out in the interview that this was in fact a fraudulent number. Well, you know, for many years the interpretation would be that fraud is only committed in this context if you are using fraudulent documents to receive a benefit under the INA. And if this person did not use the Social Security number, say they didn't use it to show at a border crossing point to get admission, or they didn't use it to convince somebody that at the border for a benefit. There are arguments, though, that because work authorization is included as, you know, part of the section of the INA, that work is considered a benefit. And Professor Wernick, I'd be interested to hear your take on this as well. But more recently, after the raids in the last year, Homeland Security has become much more aggressive, and even in some cases, people who were picked up in workplace raids, for example, if there are fraudulent documents found on them, there can be even criminal charges filed against them. So this could be very severe. Do you have thoughts on that?
Well, just to say that in most cases, working without, if a person is not caught in a raid, as Professor Newman mentioned, and they engage in unauthorized employment using a fraudulent Social Security card, in most cases there won't be any negative penalties in terms of their application for permanent residence. So the one exception that ought to be considered is if an individual makes a false claim to U.S. citizenship in filling out an application to prove employment authorization form I-9, and which is not, it's not really the problem for that person that they use a phony Social Security number, but it's that they made a false claim of U.S. citizenship. But other than that, I think you pretty much covered it.
Yeah, I just want to reiterate, especially since, you know, I come from, I used to work for immigration and I used to determine eligibility for green cards. I think I agree with Alan that, you know, working unauthorized, depending on how you're qualifying, may not be an issue, but indicating something in an application which is misrepresentation or which is not true, because in your applications that you file with immigration, you're swearing under oath at the interview, and there's a swearing on the applications that you're telling the truth. I would just caution anyone from putting false information on the applications because as Professor Newman mentioned, you may want to consider eliminating information so you don't necessarily have to put the Social Security number down, but to affirmatively put fraudulent information on application could really cause some issues at your interview or down the line if you're accused and found out to be misrepresenting to the Immigration Service, which you don't want to do. So, you know, in all of these questions, we've answered you the best we can based on the facts you've provided, but you should really seek out, in an instance like this, seek out some assistance from an immigration attorney to go over your specific facts before you file anything with immigration that may contain fraudulent information. You don't want to do that blindly. And I don't want to scare anyone, but I just really want to caution everyone about that. So we've come to the end of the question and answer portion. We received a lot of questions, and unfortunately we can't go over all of them. We received a lot of questions about topics that weren't really covered today, such as non-immigrant visas like H-1B, J-1, U visas. We had questions about consular processing, questions about inadmissibility and employment-based categories, which we will go over in future webinars. So I encourage you to continue to participate in these webinars, and your answers will be will be covered when we go over those topics. So if we can go to our next slide. So I want to thank Professor Newman and Professor Wernick about being here today, and their really thoughtful and really resourceful and useful presentation. It was really an honor to have them. If we can go to our next slide. As Alan had mentioned earlier, this web seminar, it is recorded, and it will be sent to you with an email and how to access it after the webinar. In the next couple of days, please look out for that. We can go to the next slide. And there are just a bunch of people we'd like to acknowledge that are listed there. We can go to the next slide. And, you know, unfortunately, we weren't able to answer all the questions that you had, and we will hope to answer those questions in future webinars. If you do have questions about the adjustment of status topic, or if you have questions about the webinars in general, if you have any other questions, you're more than welcome to email me. My email is listed there. It's patriciawonder@johnsonwonder.com. And I'll be happy to help you or point you into the direction of helping you as best I can with those questions. We go to the next slide. So that's bringing us to the end of this webinar. I want to, on behalf of CUNY, I want to thank everyone for joining us. And we want to invite you to our next webinar, which is March 17th. And we're going to be going over the topic of immigrants' eligibility for public benefits. So we encourage you to join the webinar and to continue to join us in this webinar series. Thank you so much.